continuation of the lecture series, I welcome you all back. We have amongst us today the Dean of School of Legal Studies at CMR University, Professor Dr. R Subramanya, who will be taking the next round of session. Professor Subramanya is currently serving as the Dean of CMR University, School of Legal Studies, Bangalore, after having served as Coordinator and Research Fellow at the Center for Regulatory Studies, Government and Public Policy in the West Bengal National Law University of Juridical Sciences, Kolkata. Prior to this, he was the Vice Chancellor of Karnataka State Law University, Hubli. He has also been the Professor of International Law at West Bengal National University of Juridical Sciences, Vice Chancellor, Bangalore University, Dean and Chairman of Faculty of Law, Bangalore University, Registrar Evaluation and Registrar in Charge Administration of the Bangalore University. He has also served as the Honorary Member of the Karnataka State Law Commission. At the international level, Professor Subramanya has served as the Legal Counselor to the Kingdom of Bahrain for over 7 years. In his capacity, he acquired considerable knowledge of the laws and legal systems of the Gulf Cooperation Council (GCC) states in the practical applications of international law at municipal level. Having pursued his MA in History and LLB with first class and securing the first rank in his LLM from the University of Mysore, he went on to secure an MPhil and a PhD degree in International Law from School of International Studies, Jawaharlal University, New Delhi in 1993. In 2009, he was awarded the Dr. Rajkumar State Award for Service rendered in the field of education by the Dr. Rajkumar International Foundation, Bangalore, and in September 2015, he was honored with the Vijayawani National Education Leadership Award for outstanding contribution in the field of education, besides several awards and honors bestowed by organizations all over the world. He has numerous papers to his credit, published in a variety of national and internationally renowned journals, and is currently the Editor-in-Chief for the UGC CARE recognized CMR University Journal for Contemporary Affairs. He is also a distinguished visiting professor for several universities, including the Symbiosis Law School, Pune, and serves on the panel of advisors, Board of Studies, Academic Council, and panel of examiners at several prestigious law schools. We welcome you, sir.
Yeah, thank you very much. Thank you for the introduction. Teaching of international law, how it is being taught now, and what improvements a teacher can make inside the classroom when he deals with the international law is the question. Now you may be knowing, most of you, the international law which was nothing but an European international law. Because most of the scholars, since they came from Europe, naturally what is being said by them is being taught. Now when we come to the 20th century, you know, the 2 world wars took place. And these 2 world wars that have taken place had an impact in the entire global theater. Now most of the colonies which were adopted or conquered or being colonized by the European powers, starting from the state of Great Britain to the state of Portugal, the state of Holland, and the state of Spain. All of them, remember, at the end of the Second World War, they had to begin in relinquishing their hegemonic rule in these colonies. Now, most of the colonies became independent. And when these colonies became independent, remember, there was a digression in the established rules of international law. Now, earlier, they would go, they would conquer, they would annex, they would occupy, and afterwards go to the extent of claiming sovereignty over the region. Now, when we come to the 1960s, especially after the establishment of the United Nations in the year 1945, all these colonies, because the resolutions that were adopted, provided in paragraph 1(3) of the Charter, they had to give independence to the colonial countries. When independence was given to these colonial countries, all of them became independent. And that was the first change that you find visible in the development of international law. Now, when I speak of the change that has taken place in this area, I just wanted to start with the source of international law itself. Now, when we speak about the source of international law, remember, earlier, prior to the establishment of the Statute of the World Court, 1945, there were 4 or 5 sources. And these 5 sources were, you remember, they just said we don't want these sources, and only 4 sources were provided. And when I speak of it, you know, customs are the source of international law, and thereafter treaties are the source of international law. And today treaties are given the fundamental place. Custom is being given the second place. Now there is one more source that is being included, and this source is known as general principles of law recognized by the civilized nations. Now, general principles of law recognized by the civilized nations is an important source. It is an important source for the simple reason most of the concepts which are developed in or originated in the municipal system today as accepted as rules of international law. Now, earlier there was no chance of accepting this. It was Professor Harsh Lauterpacht who wrote a book in the 1940s. Harsh Lauterpacht happened to be a great judge and a great scholar. He was a Whewell Professor of International Law at the University of Cambridge. Later, he was elevated as a judge of the International Court of Justice. Now, this person wrote a book, and the name of the book is Private Law Sources and Analogies to International Law. What do you mean by this? The title of the book, which runs into about 400 pages. Private Law Sources and Analogies to International Law. The point at issue is what is being practiced in the municipal system, or what is being practiced in the domestic system of a particular state. Could this be considered as a source of international law? And if this could be considered as a source of international law, could there be a recognition to this? So he was the one who championed and said as early as 1940 or 40s that these sources are to be given credence. Not only they should be given credence, but it should be accepted as a source of international law. So the Statute of the International Court of Justice came in. They said general principles of international law recognized by civilized nations must be given, remember, a place in source of international law. Now the point of speaking about this is very simple. None of the teachers, with all the developments that have taken place, when they go to the class, they only make a mention of general principles for international law recognized by civilized nations. They don't make an attempt to even explain about this. That is the reason I just thought, because any teacher teaching international law or his teaching of sources of international law is incomplete unless he takes and explains elaborately and in detail the general principles of law recognized by civilized nations. Now, I shall just give you a meaning of the general principles. Now, what do you mean by general principles of law recognized by the civilized nations? Now, when I speak of this, there are certain principles which are common in all the legal systems. These certain principles which are common in all the legal systems are commonly accepted and practiced. So what is being common and commonly accepted and commonly practiced by the civilized community of nations should be considered as a general principle of law recognized by civilized nations. Now, what principles we have in international law today, or what principles you find in the domestic sphere of a state, which are common and commonly accepted and commonly recognized under the Charter of United Nations? Now, the one instance that is being given happened to be the principles of good faith. You see, in the law of contract, it had its origin. Every person who is a party to the contract, or people who are parties to the contract, are supposed to carry out the provisions of the contract in good faith. So when it was recognized there, naturally what has happened was the same principle was recognized in treaties. They went to the extent of pointing out all treaties must be carried out in good faith. So the treaties are signed by states. States in the ordinary course of nature, when they carry on their activities, must express and carry out the provisions in good faith. Now, if this is the case, under Article 2, Paragraph 2 of the Charter of United Nations, it is simply indicated that all the parties shall act in good faith. Now, you may be knowing Article 2, Paragraph 2 of the Charter of United Nations, or Article 2 of the Charter of United Nations gives out, remember, 7 provisions. And these 7 provisions are obligations on states. And these obligations on states are to be respected and carried out by them. Now, one is, remember, you may ask me, what exactly is this? Article 2, Paragraph 1 of the Charter points out, remember, the Charter of United Nations based on sovereign equality of states. So, sovereignty, independence, and equality is the basic principle on which and under which the Charter of United Nations should work. Now, the second one, 2.2, says all treaties must be carried out in good faith. All treaties must be carried out in good faith. There shall not be any difference. There should not be any confusion as far as the obligations of a state which it has undertaken under the Charter of United Nations is concerned. So good faith, remember, is being accepted as a general principle of law recognized by the civilized nations. Now the second thing is, long ago, a beautiful case came up before the International Court of Justice. And this case happened to be Corso factory or indemnity case. And this case was decided by the Permanent Court of International Justice in 1928. Now in this case, remember, the Permanent Court pointed out the doctrine of res judicata is a general principle of law recognized by the civilized nations. Now it is recognized in the communist system. It is recognized in the oligarchic system. It is recognized in the democratic system. And that is why it is considered as a principle of law even under international law. Now what is this res judicata? Now it is a matter of the Civil Procedure Code itself. Now perhaps section 11 of the Civil Procedure Code makes a point and harps on what is res judicata. A case when once it is decided by a particular court and on a particular point, the same case cannot be heard by the same court on the same point. That's it. Simply speaking about the doctrine of res judicata. Now the same way, this was decided by them and it is being accepted, and the Permanent Court of International Justice accepted this, endorsed this, and today it is being followed in all the cases whenever it comes before the court of law. Now the second important development happened to be the doctrine of subrogation. Remember, always a loser must be given compensation and he should step into the shoes of the person who was responsible in making the loss. So there should be, the loss should be retrieved, come what may. Now the doctrine of subrogation is a general principle of law recognized by civilized nations. A beautiful case came up before the Permanent Court of International Justice, and this case came up in the year 1924. And in this case, the International Court of Justice simply pointed out the doctrine of subrogation is a general principle of law recognized by civilized nations. It had its origin in the municipal sphere. Although it had its origin in the municipal sphere, it is accepted, practiced, and today it has become part of a rule of international law. Now remember, in the year 1937, a beautiful case came up before the International Court of Justice, Permanent Court of International Justice, that is diversion of water from the river Meuse. So in diversion of water from the river Meuse, what has happened was, it was relating to the principles of equity. How the role of equity or equitable principles are playing a great role in the development of international law as well. In the diversion of water from the river Meuse, the Permanent Court of International Justice pointed out the Anglo-American equitable principles. The Anglo-American equitable principles are a general principle of law recognized by civilized nations. See, this is developed between America as well as England, and later it is being accepted in the European theatre by states. What is being practiced there is the general principle of law recognized by civilized nations was the expression. Now you will be knowing 1937 it was decided, but then it had a far-reaching impact. When I speak about the far-reaching impact, especially in the sharing of the continental shelf between adjacent states, between opposite states, the International Court of Justice repeatedly pointed out general principle of law recognized by the civilized nations. Remember, while sharing of the continental shelf for the adjacent states as well as opposite states are to be observed and are to be respected. I shall speak to you a little later about this. Chronologically, I am going. Now, thereafter, other cases came up before the International Court of Justice, and one such case happened to be the Serbian loans case. The Serbian loans case came before the Permanent Court of International Justice in the year 1927. Now, in the Serbian loans case, the Permanent Court pointed out the English doctrine of estoppel is not a general principle of law recognized by civilized nations. See, they went to the extent of pointing out certain principles are not general principles. Don't try to waste the time of the court. The English doctrine of estoppel, you know it, person is stopped from doing it, is not a general principle of law recognized by civilized nations. But then you may be knowing there are beautiful cases came before the present International Court of Justice, and one such case happened to be the Southwest Africa cases. In the Southwest Africa cases, it came before the International Court of Justice, Justice thrice. Once it came in 1949, judgment was delivered in 1950, and then came in 1962, judgment was delivered in 1966. Third time it came in again 1970, judgment was delivered in 1971. Now, in this principle, in these cases, the International Court just said the doctrine of trust is a general principle of law recognized by civilized nations. A trustee who is appointed to take care of the trust property is not supposed to abuse the trust property. You know, temples, and in these temples you have trustees. You have mosques, there are trustees, churches, there are trustees. So the trustees who are appointed to take care of the property, to look after the property, to safeguard the property, are not supposed to, remember, misuse and usurp and indulge in corrupt practices and do whatever they want, because it is a general principle of law recognized by civilized nations. You may be interested to know what exactly happened in the Southwest Africa cases. Now, Southwest Africa, when I speak about it, is Namibia. Namibia was a poor country and it was not in a position to administer itself. Illiteracy and poverty was the order of the day. And illiteracy and poverty was the order of the day. Remember, when the League of Nations came to be established, under one of the articles, Article 171 of the League of Nations, Article 22 of the League of Nations, they provided for the mandate system of the League of Nations. Now, when I speak about the mandate system of the League of Nations, it provided for a mandatory and a mandated territory. Those states who are not in a position to administer, those states which are not in a position to govern themselves, those states which are very poor, remember, where poverty is actually on day-to-day basis is dancing before the people, such states could come under the mandate system of the League of Nations. So at that time, the League of Nations in 1919, in the Treaty of Versailles, pointed out that the League of Nations will appoint a mandatory. Mandatory is a state which is an advanced state, a developed state, a civilized state, a state which is in a position to govern the mandated territory. So the territory which is poor is called the mandated territory. So what has happened was Southwest Africa or Namibia came under the jurisdiction of the state of South Africa. South Africa at that time was very powerful, and South Africa was requested by the League of Nations to take care of Namibia. So Namibia became the mandated territory. Now the point at issue is, it is the duty of South Africa to look into the administration and to see that administration is done properly. Education to the people is given. Poverty in the region is being removed. All these are to be done, and afterwards there should be independence for the Namibians. This was the objective. Now, South Africa, remember, was not interested in all these things. It wanted to colonize Namibia. Now, what had happened was Second World War was declared. And soon after the Second World War was declared, remember, afterwards, you know that I don't wish to speak about the Second World War. It was replaced, League of Nations was replaced by the Charter of United Nations. The Charter of United Nations devoted an entire chapter known as the trusteeship system of the United Nations. Now, the trusteeship system of the United Nations comes under chapter 12 of the Charter. Now, when I speak about the trusteeship system, it provided those states under the League of Nations who are not in a position to administer themselves, who are not in a position to govern themselves, those who are poor can now come under the trusteeship system of the United Nations. Now, the state of South Africa initially used to submit reports to the United Nations. And thereafter, they stopped submitting reports to the United Nations. And a question was asked, notices were sent. Then I said, we have the obligation only under the League of Nations. We don't have any obligation under the Charter of United Nations. The League of Nations died its natural death. When the League died its natural death, remember, should we submit to the supervision of the United Nations? No, it is not possible. No, at this juncture, the matter was debated before the United Nations. And the matter was not only debated, and thereafter they put questions, legal questions to be answered by the ICJ by way of an advisory opinion. So the matter was referred to the International Court of Justice for an advisory opinion. Now there are three questions which are put. Now the point is there an obligation on the state of South Africa to submit to the supervision of the United Nations? The first question. The second one is whether chapter 12 of the Charter, that is relating to trusteeship system of the United Nations, is applicable. Now the third question that is being put is, can South Africa modify the status which was conferred by the League of Nations earlier without the permission of the United Nations? Whether South Africa is unilaterally allowed to modify the status of the agreement which was entered in 1922. Now, for the first question, the International Court of Justice pointed out, no, whether the Charter provisions are applicable, they said yes. And then the chapter 12 of the Charter applicable, yes. Then for the third question, can South Africa alter the status unilaterally? No, it is not possible. Now, then again, it came, the second phase came, the third phase came. We are not interested in discussing, I just told you. Now, here in the judgment, in all the three judgments, this points out. Now, the trusteeship of property has to be applied to the context of South Africa. Because South Africa was appointed as an administrating state. And when it was administering the provisions of the territory, remember, it was doing it under the supervision of the United Nations. South Africa is a trustee to look after the territory of Southwest Africa, that is Namibia, under the supervision of the United Nations, done by South Africa. A trustee can never be and never allowed to abuse the trust property. And if trustee abuses the trust property, remember, it is contrary to the general principles established by the civilized nations. That is what the International Court of Justice pointed out. So this was one of the landmark cases which came before the ICJ thrice, and they said, went to the extent of pointing out, remember, this has to be accepted. Now thereafter we have another case. Another case came in that is known as the Corfu Channel case. In the Corfu Channel case, the International Court of Justice pointed out the issues relating to the law of evidence. The matters, we say evidence is required only in national law. No, it's not that. Same principles are applied by the International Court of Justice. In the Corfu Channel case, the International Court of Justice said circumstantial evidence is a source of law. And it is generally accepted by all states. Now, what do you mean by circumstantial evidence? Remember, certain evidence, you don't have direct evidence. But then circumstantially, a party may be in a position to produce it before the court of law. When a party produces this before the court of law, it has to be accepted. It has to be accepted because circumstantial evidence has been admitted as a source of law in all the civilized legal systems of the world. When it is recognized in all the civilized systems, the legal systems of the world, it has to be recognized as a source of law that was pointed out by the International Court of Justice. Now, there was another case that came before the International Court of Justice in the 1960, with which we are concerned. It is right of passage over Indian territory. In the right of passage over Indian territory, the issue was very simple. Remember, what has happened was, parties have submitted the dispute before the court. And the court, remember, before the court accepted, there should be what we call as compromise. Both India and Portugal, when they came before the negotiating table, were not in a position to resolve the problem. When there was a deadlock and not in a position to resolve the problem, both Portugal as well as the state of India decided to refer the matter to the International Court of Justice for a legal opinion. Now, see, there was a compromise that is being entered between them. And this compromise is being submitted to the International Court of Justice. Based on the compromise that is being submitted between India and Portugal, the International Court of Justice, now remember, invites the parties and then they admit the petition. Now, after admitting the case, at the time of hearing, can a party to the dispute unilaterally withdraw? No, this is not allowed. See, for example, parties decided themselves and they decided themselves to go and resolve the dispute, a legal dispute by the International Court of Justice. So preliminary hearing was done. Preliminary objection was overruled. And thereafter, when the hearing begins, if a party tries to withdraw from the petition, they said, we are going to hear the case. This cannot be done because it is a general principle of law recognized by the civilized nations, wherein the parties, after the admission of the case, after a compromise is submitted by them to the International Court of Justice, cannot withdraw. And this is a principle, it is being permitted in almost all the legal systems of the world, is a principle of law that is being spoken. Now, with which we go to discuss something relating to the principle of equity. Now, principle of equity is a general principle of law recognized by civilized nations. And it is playing such a great role today. No teacher teaching international law makes a reference to the principle of equity in the classroom. The very purpose of, remember, bringing these factors into this is to see that it is the duty of a teacher to bring these factors in the classroom and discuss. And it should not, the student should not think that international law is an alien law. International law, remember, ultimately emerges from the legal systems of the world. Maybe developed, maybe developing, maybe least developed. So this is how the student should be in a position to convince the students. Now, one such case happened to be a case relating to the Ran of Kutch arbitration. Ran of Kutch arbitration, which went to the International Court of Arbitration, and a judgment was given in 1968. Nani Palkiwala was the man who argued on behalf of the state of India on this. Now remember, if you look to the Ran of Kutch, the entire area you have full of biodiversity. And most of this biodiversity, which you find with the waters and other things, come on the side of India. Now, when it comes naturally on the side of India, it went to the extent of pointing out here the principle of equity has to be applied. The principle of equity has to be applied because in a few cases here and there, it is the state of India which is responsible in nurturing this biodiversity. Because it was taking care of this. It was giving protection to all this. So in such situations, it was considered as a general principle of law recognized by civilized nations. Remember, suppose for example, in the Karwar region, biodiversity is being protected by the government of India legally today. I am speaking about 1968. Even then the government is to take care. When that is being done, is the principle of equity wherein respect should be given to the stakeholders and that territory naturally should go to them at the time of dispute. This is what the International Court of Justice pointed out. Now, the other one happened to be there were other cases that came before the International Court of Justice relating to the principle of equity. Because in one of the cases before the International Court of Justice, the judge, Manley Hudson, he pointed out principle of equity is recognized as a general principle of law in almost all the legal systems from not now onwards. It was recognized, remember, time immemorial. It was prevalent during the time of the Greeks. It was prevalent during the time of the Romans. And it was accepted as a principle of law between the 6th century to the 16th century. And it was admitted as a principle of law during the colonial period as well. Now you might be knowing, the British, when they came to this country, they enacted the Easement Act, recognized the principle of equity even here. That is why it has to be respected and it has to be honored by the court. Then came what we call as the principle of equity relating to the areas under the law of the sea. Now, when I speak about the areas under the law of the sea, remember, in the exclusive economic zone, while sharing the areas of the exclusive economic zone of a state with another state, naturally, under Article 59 of the Convention of the Law of the Sea, 1992, the principle of equity has to be observed. Just read to Article 57 and 64 of the Convention of the Law of the Sea. It points out, while sharing the areas and resources which are found in the exclusive economic zone, now, the principle of equity has to be respected between the parties to the dispute. And this is the provision of 57, and similar thing is being spoken under Article 64 of the Charter of United Nations. Now then we come to a beautiful case that was decided in the year 1969. And the whole case, the International Court of Justice decided the whole case on the principle of equity. Now when I speak about this, remember, it is nothing but North Sea continental shelf cases. I shall just explain because some of you may not be knowing it at all, you will have forgotten completely. The North Sea actually is in concave shape. See, when it is in concave shape, there are three adjacent states which come in. On the one side, you have Holland. The other side, after Holland, immediately comes the state of Germany. By the side of the state of Germany, you have the state of Denmark. So if it is in a concave shape, three states are adjacent states. Holland, Germany, and the other one happened to be Denmark. Now what has happened was, somewhere in the North Sea, scientists of the state of Germany discovered oil. So in 1960s they discovered oil. When oil was discovered naturally, the state of Germany, because it was technocrat and they had the skill in exploiting the machines, in exploiting the resources, they said we are going to exploit. So at that time, the state of Netherlands, that is Holland, as well as the state of Denmark pointed out, what nonsense you are talking. It falls in our territory. It is our continental shelf. You cannot go and unilaterally exploit the resources, and share should be given. Then comes the natural meaning of continental shelf. What is this continental shelf? Now the definition which is being given under the conventional law of the sea is, the continental shelf of a country is nothing but the natural prolongation of the land territory between the seabed and subsoil. What is this? Natural prolongation of the land territory between the seabed and subsoil and the abysmal ocean floor. That is how the definition is being given. So natural extension of the land mass, natural prolongation of the land territory. Now there, the sedimentary culture is very much essential. Now the state of Germany said, we have consulted our geologists, We have consulted our geographies. We have consulted our the other scientists as well, morphologists. All the three, morphologists, geologists, and the other one, they went to the extent of pointing out the area where oil is found is nothing but the continental shelf of the state of Germany. Right, at that time, what happened was the state of Netherlands, remember, got the report through their morphologists and geologists and geographers. They said that area comes to in our territory because it is nothing but the extension of the landmass of the state of Holland. Similarly, the other side, extreme side, we have the state of Denmark. It produced a report. Our scientists are saying it should be part of it and it should be in a position to exploit. So there was utter confusion. And when there was utter confusion, remember they refer to the Geneva Convention of 1958 on the law of the sea. When we refer to the Geneva Convention on law of the sea, it says, where there are opposite states, the continental shelf of a state should be shared by equidistance. Where there are opposite states, for example, take the instance of Sri Lanka and India. So where there are opposite states, it is equidistant. Suppose, for example, you go to Rameshwaram or go to Dhanishkoti. From Dhanishkoti to the Mannar, Gulf and after. Now the distance between Sri Lanka and India is just 22 kilometers. So the measurement when it takes place, remember 1 kilometer may be considered as the internal waters from both sides. 1 kilometer from the state of Sri Lanka and 1 kilometer from the state of India. So the remaining 20 means 10 kilometers each. So where the state of Sri Lanka is empowered to exercise sovereignty and in the remaining 10 kilometers, India is empowered to exercise sovereignty. Now the problem is not related to opposite states, it is adjacent states. So what principles of international law are to be applied? Now both the state of Germany and Netherlands, they entered into an agreement. Having entered into an agreement, they requested the court what principles of international law are to be applied in a case wherein the adjacent states are interested in resolving their continental shelf area. Now there was another agreement between the state of Denmark and the state of Germany, and the same question was put and it came before the International Court of Justice for an opinion. Now the International Court of Justice heard all the parties. Having heard all the parties, remember the International Court of Justice pointed out, see, the measurement of a continental shelf take place in accordance with the convention. And at that time, the Geneva Convention of 1958 was still in force. And they said, but then when you measure the continental shelf, 3 factors are to be taken into consideration. One factor is general direction of the coast, the general configuration of the coast, and the breadth of the coast as well. So the general configuration of the coast, then direction of the coast, and then all economic factors which are peculiar to the region, if any, as it was pointed out in the Anglo-Norwegian fisheries case. And they pointed out this matter. Now, they just pointed out here what is important is always when you share the continental shelf, it is by mutual agreement. So all the parties should come together and they should resolve amicably. Where amicable settlement is not possible, where they don't come for a compromise, then remember, the disputed territory should be administered by way of an agreement. So all the 3 are trusted to take care of it, and accordingly, as per the agreement, it should be done. Where the parties are not prepared for an agreement, then what should be done? They went to the extent of pointing out it should be a regime of joint jurisdiction. Complete. There is no agreement, regime of joint jurisdiction. So when regime of joint jurisdiction or through an agreement or through mutual compromise, when it is done, what are the factors that should be taken into consideration? Now the factors are the principle of equity. They said equitable principles. Equitable principles are very much essential. Each one should get according to his ability, his area. Now, for example, the state of Germany in this case happened to be bigger in India, bigger in area, bigger in resources, bigger in population. So naturally, if you apply the equitable principles, it is to get and it should be given a greater share. So this is a principle of equitable principle. And this was applied by the International Court of Justice in the 1969 case. Now, later what has happened was there were disputes which came in before the International Court of Justice in sharing the disputes of continental shelf between Libya and Malta. Now, when the case came up, same, they said equitable principles are to be applied. Under no circumstances this can forego about this. Thereafter, again, the disputes between Malta and another country nearby, that came before the International Court of Justice. There also it said. Now the point at issue is, now these are the general principles of law recognized by civilized nations. Equitable principles, doctrine of subrogation, then doctrine of trust, doctrine of what we call as res judicata. All of them are to be brought into the classroom by a teacher. The very purpose of forcibly putting this is, unless these are told in the classroom, remember, the student will not feel at home. And he will be thinking that you are speaking some alien law. And at times for some people whose English is poor, it is beyond reach because you don't have good books in international law in the local vernaculars. That should not happen. That is the purpose of telling this one aspect. Now the second thing which I just wanted to speak on, United Nations. Now you may be interested to know why I should take up about United Nations immediately after the sources. There are reasons behind it. Now many people go to the extent of pointing out United Nations is a useless organ and it is not functional. But then if you look to the jurisprudence of the United Nations, remember it is a functioning organ, it is functioning effectively. Remember, it is functioning effectively because they have kept certain organs within the United Nations. And these organs with the United Nations is functioning very effectively. For example, the International Court of Justice. And you have the Court of Arbitration. And thereafter, you have several tribunals today, which has been permitted by the international legal system itself. That is why it is functioning effectively. I shall give you one or two instances so that to understand the point better. Now, what has happened was, initially when the United Nations came to be established, there was East-West rivalry. Now, East-West rivalry had gone that far. Remember, even the members which they took admission to the United Nations, they were watching whether he's from the Soviet bloc or he's from the American bloc. If one member were to come in from the American bloc, the second one naturally should be from the Russian bloc. Unless this is balanced, they would not allow anybody to get in as members of the United Nations. Now, by 1954, there were 16 members who wanted to become the member of the United Nations. But then they were not allowed because they were not equal. Eight of them in between 8 members from the Western bloc, 8 members from the Eastern bloc. So ultimately, remember, after some time, all the 16 members were admitted because they were equal, 18 members. 9 from the American side, 9 from the Democratic side, 9 from the Communist side. That is how it was done. That was the fight that was going on. Now, after the admission of these states, what important developments have taken place? Now, one important development happened to be the admissions case that came before the International Court of Justice by way of an advisory opinion. Now, the point is, can the General Assembly, I shall tell you Article 4 of the Charter so that you understand the point better. A member to the may be admitted on following certain criteria. The first criteria is the member must be a state. And when I speak about a state, the Montevideo Convention come into operation. A state shall have a population, a defined territory, and an established government, and a government to which the people who are residing there owe habitual obedience. And if these conditions are followed, then the concerned state is eligible for admission. All admissions take place only on the recommendation of the Security Council, followed by a decision of the General Assembly. One case came because some of the states, remember, they knew Security Council is not going to admit us. So at that time, they wanted straight away to go to the General Assembly. Now at that time, the matter was referred for advisory opinion. Can the General Assembly admit a particular member without the recommendation of the Security Council? This was one of the questions that came in. Now at that time, the International Court of Justice, having heard all the argument, they said no. You can admit, you can reject the recommendation, but then without the recommendation of the Security Council, you cannot admit a member of the United Nations as a new member of the United Nations. See, this was a landmark decision because the General Assembly wanted to see what Security Council, there are only 5, we are 150. We are also sovereign states. No, they have become members because they are, at that time they were powerful. Now they are nothing, poor also in the 21st century. So these arguments were put an end. They said, you are empowered to reject the recommendation of Security Council, but you cannot admit without its recommendation. Recommendation has to come. Afterwards, you deliberate and take a decision of consensus amongst you. So this was one of the major resolutions which nobody tells in the classroom. Now another one is, remember, deliberations take place in the Security Council. You see in the channels, especially in English channels. And all of them, they speak, they shout, they hate each other, all of them they do. When the matter is put to vote, the concerned states which have spoken vociferously are missing. Some of them, they go to the library, some of them go to the canteen, a few of them will be in the refresher room. And this became a problem in 1945 to 1949. So you participate in the debate, but at the time of voting, remember, you disappear. You don't want to take a decision. Now, the International Court of Justice, this matter went to the ICJ for an advisory opinion. When the matter went before the ICJ, for the advisory opinion, the ICJ pointed out, a member is supposed to vote because it is given the power. So 15 members, remember, speak vociferously, and afterwards at the time of voting, they will disappear. This is not allowed. Under the charter provisions, each member shall vote either positive or negative. And if you what we call as absent yourself, if you absent yourself, the presumption is you are supporting the majority decision of the Security Council. Thereafterwards, everyone started attending. Otherwise, every time 15 members are being, let the permanent members shout, why we should bother? They will speak against. Afterwards, they will disappear because they don't want to take a decision because the decision may be against a permanent member. Then the ICJ said, all states who are members of the United Nations, the Security Council, are supposed to be in the meeting. Article 25. And after the deliberations, they are supposed to vote when it is put to vote. And if they don't vote and they deliberately abstain, they will be supporting the majority decision. That is being pursued by the Security Council of the United Nations. This is what they said. That actually helped in the development and progress of international law. That has to be told by a teacher in a classroom. Now the other important development which speaks about the principle of equity as well, happened to be a beautiful decision which nobody makes a mention. Effect of awards to the administrative tribunal. I'm just asking you, those teachers who teach international law, whether they know this case. No, these are the cases, remember, which led to the development of international law. Effect of the awards to the administrative tribunal, 1954. I shall just tell you briefly the brief history of this. Now, what has happened was, the Secretary General of the United Nations appoints all staff members of the United Nations. There must be thousands of them, and appointment order naturally goes, remember, in the name of the Secretary General of the United Nations. Now, for the efficiency, competency, and highest standards, the United Nations Charter provided for the establishment of an administrative tribunal. If you look to the Travax preparatories of the United Nations, When it was formed, there was a lot of discussion between 1943 to 1944-45. They said in order to maintain the efficiency, competency, integrity of the United Nations employees, there shall be an administrative tribunal. And this administrative tribunal should be a judicial organ, not a political organ. So the administrative tribunal thereafterwards, when the United Nations came in, was appointed. It is composed of 7 members. And they are qualified people in international administrative law as well as international law. So what happens is, in the event of a termination of the contract of service, in the event of a suspension of the contract of service, in the event of not providing dues which are owed to an employee, the employee is allowed to pursue the matter before the administrative tribunal. So he can straight away go and pursue the matter and challenge the decision of the Secretary General of the United Nations because he acts on behalf of the United Nations. Secretary General of the United Nations is not only the head of the Secretariat, but he is also a head administrator and the chief executive of the United Nations. He is the chief spokesperson of the United Nations. So in the event of any decision which is ultra vires that is being taken by the Secretary General in terminating, dismissing, suspending, whatever, the people can go before that. Now what has happened was, there was a problem that came up in 1946. Some of the American nationals were appointed in submission in Europe. And these American nationals, when they were appointed in Europe, they have leaked certain information. Leaking certain information is against professional conduct of the United Nations. You are not supposed to leak out information. You are supposed to maintain the highest standards of secrecy. Now, when this was done, remember, this appeared in the Washington Post. It appeared in the New York Times. It appeared in the BBC. And the United Nations wanted to initiate action. And immediately America said, we are going to appoint a federal commission, federal grand jury. It will be headed by a federal grand jury. Let the United Nations not get involved. So, federal grand jury, a commission was appointed by the American government and commission started functioning. 11 American employees were involved. And these 11 American employees, when they were summoned, they refused to go before the tribunal. When they were asked why you are not attending, they said it is self. No one can be witnessed against himself. We are not going to attend the tribunal, nor are we going to give evidence against us, which is just not possible and unthinkable. So from there, it came back to the table of the Secretary General. Now, the Secretary General referred the matter again to the Administrative Tribunal. And the Administrative Tribunal, remember, awarded compensation. And the compensation awarded by the Administrative Tribunal was huge. It was about something like $1,796,000 at that time. I'm telling the story of 1946-47. So this compensation was huge. And ultimately the compensation which was awarded by the Administrative Tribunal has to be approved by the General Assembly. So the decision of the Administrative Tribunal given by the Administrative Tribunal came before the General Assembly. The General Assembly started deliberating it. And when it started deliberating it, it said, what nonsense is this judgment? We are not going to respect this judgment. We are not going to respect it because Administrative Tribunal is constituted by us. And judges are appointed by us. How they can write a judgment against the General Assembly? Can they write a judgment against us? It is ultra vires. This is how they started shouting. When there was a deadlock and when there was pressure for the compensation for the employees who were dismissed and terminated, remember the Secretary General, with the help of the General Assembly, refers the matter to the International Court of Justice. And when the matter was referred to the International Court of Justice, there was only one question. Is there a duty on the part of the General Assembly to respect the compensation awarded by the administrative tribunal? Yes or no? Then if the answer is yes, then the next one, how the procedure, how to pay the compensation. Now, when the argument was going on, before the court, argument has taken place in such a way, first and foremost, look to the TREVAX preparatories. And in the formation of the United Nations, during the course of the formation of the United Nations, the parties have agreed that there shall be an administrative tribunal. And this administrative tribunal shall be a judicial organ. And matters relating to employment contracts can go before them, by the administrative tribunal. And once the judgment is given, remember, it is res judicata. There is no appeal. So what the court said ultimately. So argument went on and the court simply wrote, the judgment of the administrative tribunal is res judicata because it is a judicial organ. And this principle is being followed in almost all the legal systems. And this cannot be opened for hearing except with the permission and consent of the administrative tribunal, which he did not do at that time. Now they said it is a principle of equity. That is why equity is called, if you look to C.K. Allen Roman, the law in the making, wherein it says equity is the foot of the chancellor. Equity is the second kind of justice. That is why it had to be respected. I'm just telling you, they simply said in the court, when once it is decided by the administrative tribunal, being a judicial organ, it is binding on the parties, including the United Nations General Assembly. And the General Assembly is supposed to, remember, accept this. They cannot say no. These are the questions which were answered in such a beautiful way in this concerned case. Now, there are other important developments which have taken place. In 1946, there were several debates which were going on in the General Assembly. And when the debates were going on, maybe there was a Greek crisis, there was a Palestinian crisis, there was the Iraq crisis that was going on, many of them. I can mention about 50 of them if you want. Now, when these crises were going on throughout in many parts of the world, Lebanon crisis. Now, what has happened was, the matter was started, had put in the agenda of the General Assembly and the debate started going. When the debate had taken place against a country in the United Nations General Assembly, the members or representatives of that country walked in and walked out in protest. He said, you cannot discuss our domestic matter. What nonsense you are doing? No, it is a domestic matter, and domestic matter cannot be discussed by the General Assembly. In the Greek crisis, in the Lebanon crisis, in the Cyprus crisis, the representatives, even UK, in the Rhodesian crisis, walked out in protest. It went to the extent of pointing out, no, nothing. But in spite of their walkout, the matter was discussed and a resolution was passed. Now, after 10 years, between 1945 to 1955, what exactly is the development? The development is very simple. And today it is a rule of international law which no student tells in the classroom. Now, any colonial question is not a domestic matter. Get the point? Suppose, for example, South Africa was ill-treating the Namibians, that is the Southwest African people, and it is practicing apartheid there. It is ill-treating the people, hunting them, and all the resources which belong to that territory is being taken away from Namibia to South Africa. Do you mean you cannot discuss this issue? Do you mean the entire world community have no concern on these issues? We have a concern. A colonial issue, a colonial matter is not a domestic matter. It has to be discussed, come what may. Then thereafterwards, remember, they went to the extent of pointing out the other important is discussion when we carry on. It is not resulting in intervention. See, discussion as such will not lead to intervention. Suppose, for example, you sit together there only, and you may be talking so many of the things about some other persons. Does it lead to intervention with this privacy? It is only a talk, maybe a tall talk, if you want to. Otherwise, it can be a lower talk. So discussion as such never tantamount to intervention. That is what the International Court of Justice pointed out. They can discuss anything. They can discuss anything within the scope of the Charter of United Nations. Discussion is not an interference with the internal affairs of the state. Now the third thing is, remember, once a state has ratified a treaty, that is the Charter of United Nations, can it go against the provisions of the Charter? Now when you are supposed to become a party to the treaty, international treaty, that is the Charter of United Nations, consequent to that, you have become a party and ratified it in your constitution in accordance with the constitution provisions. Can you go against the principles of the Charter? That is what it is pointed out. Everyone is supposed to accept the principles of the Charter of United Nations. Now then, there is a provision under Article 2, paragraph 6 of the Charter. Article 2, paragraph 6 of the Charter of United Nations imposes its universal character on everyone. What does it say? Article 2, paragraph 6 of the Charter points out even non-members of the United Nations are supposed to act in accordance with the Charter. Whether you are a member of the United Nations or not, that does not matter. But you are supposed to act in accordance with the principles of the Charter of the United Nations. So it imposes obligations even on non-members. Now then came in again, there is a supremacy of the Security Council and the General Assembly. Now that beautiful case came before the International Court of Justice as early as 1954. And this is known as the certain expenses case. See, what has happened was, certain issues came before the Security Council. The Security Council, because of their politics, because of their supremacy, was not in a position to take any decision. And remember, it was pending there. And at that time, the Secretary General, he was also equally powerful. Dag Hammarskjöld, very powerful Secretary General. Tryggvi, again, Norwegian, very powerful Secretary General. Now what they did was, from the agenda, from the table of the Security Council, they put it before the General Assembly. And if they are not discussing, now the matter be discussed with General Assembly, let the General Assembly take a decision. So what has happened was, remember, in the Korean crisis, when the Security Council was not able to deliberate, the matter goes to the General Assembly, and the General Assembly takes a decision in establishing the United Nations peacekeeping. So immediately, to suspend the hostilities, to see that the parties should remain where they were, forces were constituted, and these forces go to the spot and suspension of hostilities take place. Now thereafter, remember, after a few years, the expenses came in. And these expenses ultimately were to be approved by the Security Council, because Security Council under Article 24, primary responsibility of maintaining peace and security is with the Security Council. Primary responsibility of maintaining international peace and security is with the Security Council. So it has to be approved. The Security Council said, we are not approving. The forces are constituted by a resolution of the General Assembly. Soviet Russia said, no, we will not approve, come what may, because we are not a party to it. And it is only the General Assembly which has, remember, endorsed by a resolution for establishing United Nations peacekeeping. When there was a deadlock in not getting the approval either from the Security Council or from the General Assembly, the matter went to the ICJ. Now ICJ, having deliberated the matter, ultimately gave a beautiful decision. It said, look to the provisions of Charter. It simply says, primary responsibility of maintaining peace and security is with the Security Council. It is the primary responsibility, but not the exclusive responsibility. Suppose because of some inherent defect under the Charter, because of East-West rivalry, because of some misunderstanding, if you refuse to restore peace and security, the matter can be deliberated by another organ, which is also a competent organ to maintain international peace and security. That is where primary responsibility rests with the Security Council, but not the exclusive responsibility. Whether any teacher tells, whether teachers of international law these things. That is where, now these are the things which are to be taught inside the classroom so that they will appreciate the United Nations. These are the judgment which are delivered by the International Court of Justice. Now then thereafter, I just wanted to speak about developing countries perspective. Always when he teaches international law, developing countries perspective will have to be brought into the classroom. And if you don't bring in developing countries perspective into the classroom, it is a waste of teaching international law. Now, what are the type of treaties which are being signed? And these treaties which are being signed are based on or modeled upon the universal application of the rules of international law. Now, for instance, I just wanted to tell you about developing countries perspective, especially in JNU. I went to the MPhil course also, and all the teachers, especially Professor Chimney, for everything, he will start from the developing countries perspective. Now you may ask me how it is being taught from the developing countries perspective. First look into, are there any organs under the United Nations exclusively appointed for helping the developing countries? In the year 1962, there were two organs which came in exclusively to cater to the needs of the developing countries. One is UNCTAD, United Nations Conference on Trade and Development. United Nations Conference on Trade and Development is appointed or set up exclusively to take care of the problems of the developing countries and the least developed countries. Now the other one is UNIDO, United Nations Industrial Development Organization. UNIDO happened to be an organization which is being set up only to take care of what we call as the problems of the developing countries or the least developed countries. Then you have, under the present day international law, you have many of them. Now I will just give you, now I will explain along with this what is instant customary rule of international law. But I am speaking about developing countries. Now instant customary rule of international law is such a rule which is being coined by one of the professors in the University of Harvard, Louis B. Sohn. A Harvard Louis B. is initial, Sohn, S-O-H-N. Now he was saying that when a resolution is kept before the General Assembly, permission is being sought. And when permission is sought from the General Assembly, then only the matter will be discussed. After the discussion, when the resolution is, remember, passed with the voice vote, with the voice vote without a difference, remember, it is a consensus decision. And it is a decision of consensus, and this decision of consensus is nothing but an instant customary rule of international law, which has to be accepted by the community of nations. I will give you three instances so that you understand the point better, which because nobody tells in the class. Now, one is the resolution on sovereignty over the natural resources, 1960. In 1960, a resolution was adopted by the international community on sovereignty over the natural resources. And this was adopted with a voice vote. There was no dissent. Now, when I speak about this, each country which has become independent, a country which is earlier was a colonial country, now it has become independent, is in a position to explore and exploit the resources by itself. Under no circumstances, neo-colonialism can take place. It has to explore and exploit the resources by itself. Now, this is a rule of international law today. Now, the colonial masters cannot go back and say, we are going to exploit, we will come. No, permission can be given, but then again, it is left to the privilege of the developing countries. Now, thereafter, we have the resolution on self-determination. In 1956, a resolution was adopted, and this resolution was adopted independently without any objection by any country. What is this self-determination? Countries, remember, who are colonial, are ruled by other masters, are independent to become independent state. They are independent to choose a form of government of their own choice. They can become communist, or they can become democratic, or any other government which is available in the world. So the resolution on self-determination, remember, is a resolution which is accepted by consensus. Then there is what we call as the Economic Rights and Duties of States, 1974. There was a declaration on economic rights and duties of states. And this economic rights and duties of states was also adopted by the voice vote. Now, these are all for, remember, developing countries, for their help, to come to their rescue, to support them. Now, there is one more resolution, important resolution, which no teacher tells in the class. This is called as the Resolution on NIEO, New International Economic Order. Resolution on New International Economic Order was, remember, came in force in the year 1974. Now, this resolution of 1974 naturally speaks of helping the developing countries, least developing countries. Now, first one is regarding raw materials. Developing countries may not be having the raw materials for which the developed states which are competent enough should help them. Then the transfer of technology. Transfer of technology because they are in a position, not in a position to produce anything. And for which transfer of technology is the most important thing which has to be given by the developed countries. And that has to be given by them. So the entire new international economic order is dependent completely on this. It speaks further. Resources, economic development, because initially it says 70% of the population naturally are from the developing and least developed countries. 30% of the population are from the developed world. And when 30% of the population own the resources of this, more than 70%, naturally it is their bounden duty to come to the rescue of these states. And this is in order to maintain peace and security. And if it is not done, there will be disturbance to the international peace and security. That is why help them economically, help them industrially, give them the technology. Don't give that old technology. This is what at a later stage what has happened was when the issue came relating to multinational organization, the technology that is being given to the developing countries happened to be the worn out technology in the developed world. And this should not be allowed to be done. At the point, they should also be given new technology so that the problems are resolved. These problems, there are plenty of them, you know, in India itself. And there are politicians who try to create problems in these areas on day-to-day basis. Well, at one stage, people are trying to resolve, and other stage, you are generating new problems. This should not happen, and it should come to the help of them. Then the other important resolution which is pointed out at a later stage happened to be another resolution which was adopted in the year 1970 on new international law, friendly relations and cooperation among states. Now this friendly relations and cooperation among states was adopted on October 24th, 1970. To celebrate the Silver Jubilee of the United Nations. So while celebrating the Silver Jubilee, 25 years of United Nations, the resolution on friendly relations and cooperation among states were adopted. Now this is, remember, relationship can go only by mutual trust. And the developed world, remember, should not waste the resources, they should give it to the developing world. And many things are being spoken under these resolutions. You just find out, type out 1970 resolution or declaration adopted by the United Nations. Now, having spoken happened to be, I just wanted to speak to you a few of the decisions of the International Court of Justice. And before that, just I intend to speak about the application of the rules in the area of environmental law. Rules of international law in the area of environment are being applied today. But most of the rules are of domestic origin, which nobody tells. Now, for example, you take an instance relating to trial smelter arbitration case. Now, the principle that trial smelter arbitration case today has become a jus cogens. It has become a norm of international law. It has become a norm of international law because Principle 21 of the Stockholm Declaration points out states have the sovereignty and sovereign right to do what they want. But when they exercise their sovereignty, they are not supposed to harm the interest of other states. Suppose, for example, you can do whatever you want as a state. You can do anything. But then when you exercise those rights, you should not infringe the rights of other states. No, this was originally, remember, it came from the state of Germany long ago. Now today it is a part of the rule of international law, environmental law. Now you may be knowing the Trans-Smelter Arbitration 1929, and ultimately settlement was made in the year 1937. What has happened was a factory within the state of Canada was releasing. It is bordering the state of Canada and the United States, just 10 miles. And this factory, trial smelter, was releasing zinc, lead and sulfur and carbon dioxide. And these noxious fumes released by the state of Canada, remember, travel through these 10 kilometers and get into the Columbian River Valley. Having gone into the Columbian River Valley, they enter the state of Washington. Having entered the state of Washington, they destroy standing crops. They destroy timber. They destroy what we call as the natural crops, herbs and environment. So in circumstances such as this, the matter it was known to the state of came to be known to the state of United States, they were upset. And they said compensation has to be paid. And in the 1937 decision by the Court of Arbitration, they accepted to pay the compensation. Now I am just telling you, today it has become a universal rule of international law. Because Principle 21 of the Stockholm Declaration has been recognized in the Rio Declaration in paragraph 2. It is repeated. States have the sovereign right to do what they want. But it should not lead to disturbing the sovereignty and sovereign rights of other states. It is being accepted in principle Article 3 of the Convention on Biological Diversity. How many conventions you have? Whether any teacher speaks about it or makes an attempt to know whether these things are found in which convention. So this is, remember, a student when he teaches international law, this should be at his fingertips. Principle 21, Principle 2 of the Rio Declaration, Article 3 of the Convention on Biological Diversity, and other conventions which are being accepted today. And all of them, they say, you do what you want, but then you should not disturb others. That is where, remember, the entire, environmental law, the edifice of environmental law is based upon. Now the other, I spoke to the resolutions of General Assembly, then developing countries perspective. Professor Chimney, when he used to speak, remember, I just pointed to you the resolution on friendly relations and cooperation of states. In a semester of 4 months, he taught us 2 months only on this resolution. How essential are developing countries and how essential their natural resources are to be preserved and protected. How essential the cooperation of the developed world is essential for the growth of these countries. Now, these are the things which are being spoken hard. That is where we harp upon. The whole edifice of international law is dependent upon this. Because if you teach this way, it will develop some kind of trust in the minds of students. Otherwise, it will not. Now, the last point I just said, something I will be telling you on relating to the place of tribunals. Now, the place of tribunals, remember, you have several tribunals today. Ever since the establishment of the Nuremberg Tribunal, several tribunals are appointed. You have the WTO tribunal itself and other tribunals which are functioning very effectively. Now, all these decisions, remember, are given by competent men. And these competent men, when they give a decision, remember, it is accepted by the parties. Not only it is accepted by the parties, at a later stage, it is being followed by the parties as well. That is where the true strength of international law lies. And I think it is over. And if you have any questions, I can answer. Yeah. Anybody? No question means nobody understood anything.
Yeah.
Yeah.
So whether The precedent is considered as a source of international law under Article 38.
Okay. Now, it's good that you asked. In fact, development of international law with the International Court of Justice, I forgot, slipped away from the mind. Now, I will give you 2-3 instances. So these cases you may be knowing. The first case happened to be a reparation case. And in the reparation case 1949, the International Court of Justice pointed out the international organizations have a personality of its own. See, it has a personality of its own. Since it has a personality of its own, it can sue as well as be sued. So this is the point International Court of Justice said. And the point is, when once this matter is settled and decided, should this matter be decided again by the court of law? Now, many people go to the extent of pointing out the decision of the International Court of Justice is only persuasive, it is not binding. But when certain decisions are being given by the International Court of Justice, they are binding because the matter is settled. And that acts as a precedent. I will give you one more instance. One more instance happened to be the decision of the International Court of Justice and the sharing of the territorial waters and the measuring of the coastline between the state of which country? Yeah. Now I shall explain the Anglo-Norwegian fisheries case. Have you at least remember now? Anglo-Norwegian fisheries case, what has happened was the King of Norway issued an ordinance. And having issued an ordinance, he selected certain points. And these points are to be measured in the waters of the coast of the state of Norway. And the area outside the waters, outside the 48 points are considered as territorial waters. And the waters which are inward side of the shore is called as internal waters. Now, the International Court of Justice pointed out, territorial sea of a particular state can be measured either from the low water mark or from the baseline. Now, the president came from the state of Denmark because they are the ones who selected certain points. And when once they said these points which are adopted by the state of Norway is genuine, the International Court of Justice, remember, put 2 caveats there. It said you can have the box method. When I speak about the box method, you just go to the water of the sea. Now you maybe certain small islands, certain rocks, certain fidgets, certain roadsteads that you find in the coast. Either the rocks or the fidgets or the roadsteads or the islands, all of them can be joined one by one. First there is a rock, then there is a small island, then there is a fidget, then other things. And this can be joined. But then when you consider it as your baseline, it should not deviate from the general direction of the coast. Suppose, for example, in order to get more territorial sea, you fix one rock here and another there, another fidget there, so that you get entire thing for yourself. So the fixing activities will be taking place by your state only. Others are not allowed. They are banned. Such a thing cannot be done. This is what the International Court of Justice said. So in this case, the decision which was given by the International Court of Justice is acting as a precedent. Territories, what we call as waters, can be divided and separated only by what we call either low water mark method or the box method, which I have just indicated. There are such decisions in plenty, not 1 or 2. I can just cite. Now, for example, when I was speaking about the doctrine of equity, there was a case which came before the International Court of Justice. And this case happened to be a case which came before the International Court of Justice in 1970. And in this case, the parties happened to be the state of Spain, the state of Holland, and the state of Canada. Now, the main problem in this case is whether anybody can expose the claim of shareholders in the event of loss. Now, the International Court of Justice has pointed out shareholders don't come into the picture at all. And since shareholders cannot come into the picture, shareholders' liability comes if an action directly is initiated against the shareholders. That's the point. If an action is initiated against the shareholders, then it comes into the picture. Now they said this is based on the limited liability of shareholders. Now limited liability of shareholders is part of the company law. And limited part of shareholders originated in municipal law. And what is originated in municipal law has been accepted by the International Court of Justice as a general principle of law recognized by civilized nations. And this matter, should it be recognized again when once it is said that? That is the way the Judicial International Court of Justice is being respected with a great esteem, with a great honor. And without knowing everybody, no, that matter is decided, you cannot ask them to decide again. This is the respect. Anything? Anybody? Any questions?
Sir, I would like to ask one question.
Yeah.
Good afternoon, sir. Thank you for the session first. I just wanted to ask you, one of the first things that we learned in international law is we are taught that international law is a weak form of law. This was a statement given by Austin.
Yeah,
I wanted to know from you, in today's time and age, when you spoke about the growth of international law, we are also studying the third world approaches. Is that statement still relevant? International law is a weak law, or has that changed?
Now you go back to the 19th century, and this statement was actually made by Austin. Remember, he is the one, he said, it is nothing but it's a weak law, it is the vanishing point of jurisprudence. No, it is true. At that time, because at that time sovereign states were ruling the world. And sovereign states, remember, with the dictatorship or with the what we call as the monarchy was very powerful at that time. And this writer was a child of the product of his time. As the product of the time, wherein you find monarchic rule, monarchic form of government which was ruling the world, what he said was right. When we come to the 21st century, after 150 years, this cannot be accepted. Everyone is speaking about democracy, even in the communist regime. You may be knowing what is happening there. Now, democracy is the order of the day. And basic human rights which are not respected, is not obeyed. Naturally, there will be an outcry. So it cannot be accepted at all. That was they said it was accepted there, and many people spoke about it. And today's world, that is why we speak about what is that international. It is nothing but a global world. We had a professor of international law by name R Anand. R Anand happened to be one of the brilliant scholars of this century. He passed away about 10 years ago. And he always used to speak about international law from the developing countries' perspective. He was given a scholarship to work on the origin and development of the law of the sea at the East-West Center, Hawaii. And he was there in the East-West Center, Hawaii for almost 3 years. And he produced this, and it was published by Martinez Suthoff from Holland. The book is being published. And always, unless you take the principle and the applicability of the principle from your countryside, it is not going to materialize the development of international law. This is what he was saying, and this is true also. And when he was arguing, somebody, Chimney always used to say, when the argument used to take place in the International Court of Justice, where developing countries are involved, the books which are written by R P Anand used to be there on the table of the judges. Because the people who argue the case, naturally the counsels would produce. He has written a beautiful book, Developing Countries in International Law. And he is the one who delivered the Hague lectures twice, at the Hague Academy of International Law on sovereignty of states. And he is the one who said, people have, remember, 3 chickens on the dining table, wherein the people who are not even able to see eggs. No, purchasing capacity is nil. Is this the rule of law, international law you want? So if you have, you should give us, so that we also become developed, or at least will be able to maintain subsistence. This is how international law should grow. Thank you.